COVID-19 update is brought to you by Full Text Systems. You'll come for the price, but stay for the service.
And we're back, and we're moving into our first conversation for this morning as we tackle some of the burning questions when it comes to employment and unemployment issues in the country, especially in the context of the state of emergency. We have with us on set Attorney at Law, Audrey Matura. Good morning, and welcome back.
Good morning.
Thank you. Notice I have no paper today, right? So I have to rely everything on my phone this morning. But thanks for having me, because the issue is very burning, and I'm hoping that I'm able to address more than just the labor law, because I honestly have so many questions that touch employment. And I don't know if people will be typing and asking
I'm
questions.
sure they will.
But I have some that I would want to address. So I don't know how you all want me to start.
So I want to start with definitions, because it's been absolutely clear that what the law prescribes in terms of firing, or there's a terminology of layoffs, termination, redundancy, and we need to kind of understand what all of these means and what the implications are.
Good. Well, I like to go always to the legislation.
Okay.
And so what I have here, so people need to know that we have a labor law.
Yeah.
And the last update, like revised edition, was 2000 and 2003. And then there was an amendment in 2011, which is the one that we rely on.
Okay.
And I don't want to go into too much reading, other than to make people know that, listen, when it comes to employment, termination is addressed at Section 37, where it says, look, in the past, your employer, if they want to terminate you, they just need to tell you why and terminate you. But since 2011, they don't need to give a reason. They could just say, here, thank you, Gavin, for your service. Here are all your benefits. Goodbye. I found that to be very strange, but it exists. But there are other little areas where they can just tell you goodbye. So that's termination. Which other one you asked me for?
Layoff and redundancy.
Okay, well, we don't really use layoff in a legal sense in the legislation, because layoff would be the same as termination if we had to use the common language. What we do use is unfair dismissal. That's mean that they use Section 37 telling you that they're dismissing you, but there's an underlying issue that you could have tracked. Maybe you've been sexually harassed, you've been complaining, and they don't want to deal with that, so what they do, they terminate you. And then there is the redundancy. Now, I think for this time right now, redundancy is the most important one, because a lot of people, what I have said before is that people need to understand if they're being terminated on the basis of redundancy, or if what is taking effect is a section we call Section 32 of the Labor Act, which is you're not terminated, but you can't be paid during this time. I think that's what I need to explain. So let me take time to explain that one, because that's the one that people are mistaken about. Under our labor law, without reading all the details, I can give a synopsis. Section 32 of the Labor Act says that basically, if you show up at work, even if your employer doesn't give you anything to do, they still have to pay you. Or if the store was to open and they, for whatever reason, they don't open the store today, you still showed up at work. They still have to pay you for that day. There are exceptions, though, and one of the exceptions is when there's an act of God. An act of God is defined as something in nature beyond your control. So let's say there was a hurricane, and as a result of the hurricane, the store is closed for 5 days. So for 5 days, you're not terminated, you're still lawfully employed, accruing all your benefits, but they cannot pay your salary, because the law says if they're not making money, how could they pay you? When I said accrue your benefits, one of the things, though, I would ask employers to please do is continue paying your Social Security for your staff. So under that section right now, many businesses that close down do not have to pay the employee, because it's an act of God. My interpretation is that for those who told their staff go home before the state of emergency, my interpretation is that you should be paid, because you took it upon yourself to say, don't come back. We won't give you any task to do, but you have to go home and we have to pay you. However, I said that changed the minute there was a state of emergency, because you see, we always knew there was a pandemic, but we never acknowledged that the pandemic was impacting us immediately. Under state of emergency, it's a clear pronouncement of the government that, look, we have to go into a state of emergency because now this act of God, this pandemic, has reached our shores and it has created changes or differences. That's how I interpret it legally. Maybe some people would say, no, the minute we knew there was a pandemic and they sent you home, the Section 32 kicked in.
And
I say otherwise.
Yeah, I was going to say that one other thing is that many employment contracts will also have a clause in there talking about force majeure or acts of God in there. So I'm just pointing out that for both the employees and the employers that you might also want to review the terms of your contract as well, because even though there are statutory requirements that have to be in there, there may be specific things that are set out in your employment contract which you have to pay attention to as well.
Yes, and the thing is, we've never had something like this. I mean, a hurricane for a day or two, maybe 5 days the most, a week the most.
Yeah.
This is unusual.
And you're physically incapable of getting to places.
So I'm saying once it was a state of emergency, I believe that clause kicked in full. And remember, under that state of emergency, one of the things that the government did or stated under the regulations was that certain businesses had to close. So then it becomes official. You know that Section 32 kicks in. That's mean employers do not have to pay you. Employers are not paid, but you're still legally employed. You know, it's just your payment you don't get. You're still accruing your vacation. You're still accruing your sick leave and your every other thing. And that's why I'm imploring employers, even if you can't pay their salary, please pay their Social Security contributions, because if they get ill, Social Security will only pay you if they see that you have, I think it's 15 consecutive contributions. And if 15 is not the number, well, forgive me, but it has to be consecutive contributions.
And I think right now the relief under Social Security includes that the employers don't have to pay Social Security, but they do have to file. So it's like you're paying, you just don't put the money forward.
Right.
But I want to come back to something you said earlier. There were places that, let's look at the tourism industry specifically, that saw the impact of the pandemic long before we moved into a state of emergency. You're talking hotels, restaurants, many different things. And I think at that time, people weren't sure how to handle it. Some people decided to let go a part of their staff. They were terminated. And some people asked their employees to go home and not be paid. Is that something that can be done, and what does that mean? I mean, in the law, what is there a terminology used for that?
Well, you see, this is where, to me, there's a bit of gray area, and I would have wanted either the state of emergency proclamation and regulations to address it, or the Labor Department, because in my strict interpretation of the law, because there was not yet a state of emergency, there was no declaration that places needed to close, I believe that you were still lawfully employed. And that's why one of the things I kept asking for 3 weeks ago when all of that was happening was declare your state of emergency. A state of emergency has different levels you can do. That state of emergency would have put us on footing to deal with these legal issues, because to me, the redundancy clause under a state of emergency only kicks in, or under a pandemic or act of God, only kicks in when the state of emergency makes it clear that this is what we're dealing with. So that was the before shocks, the tremors. Then we actually had the impact that we said there is a state of emergency, and then of course we'll have the aftershocks. So I use the word redundancy, and I think people need to understand it. It's a whole lot of explanation, but for the purpose of this show, I will only use the parts we need. It basically says that Section 45 of the Labor Act, as amended in 2011, that if a business have to close in part, close fully, change the method of employment, downsize or whatever, there are several reasons you can do it. And one of the reasons is that there's a act of God, a force majeure. Those are just terms saying that something beyond the control has taken place in nature. Usually when we think about in nature, we think about hurricanes and tsunamis and floods and so. But a pandemic, although we are hearing all types of theories, it's an act of God in the sense that nobody can control it. It's blown out. If we could have contained it, it would have happened already. It's a force of nature beyond our immediate control. So under Section 45, they're saying, look, if the employer wants to make you redundant, one of the reasons they can make you redundant is for that. What I had said before was that if Section 32 kicks in and the employers realize I don't have to pay my employees, but because Section 32 says there's an act of God, they can decide I won't pay them, but they'll stay employed. Or they might say, you know what? The future of this company, of this business is uncertain. So even if I keep them employed after 30 days, I don't know if we could make it back. If they want to terminate you at this point, that's mean they want to end your service at this point, it would then have to be under redundancy. Redundancy is important because it carries certain legal protection. One is if you are making your employees redundant, you must inform their union, if there's a union, labor representative or employee representatives at the company if there's one, and definitely the labor commissioner. The reason being that the labor commissioner then needs to know, okay, this business is going to be able to, it's going to make redundant 5 people, 10 people, 20 people, because redundancy is usually in a bigger group. I need to know who they are. I need to know how many years of service, what benefits they have, and I need to know if there's anything we can talk with the employer that could help them keep on some people, because the last thing we want is for people to just lose their jobs.
Yeah.
So that's when redundancy kicks in. But you have to follow those procedures, and you have to do it at least a month before the actual termination. It could be a day or 2, but at minimum a month, or the most up to a month. You can't just do it on your own. I don't know if the Labor Department has gotten many of those requests. When you are made redundant now, you get all your benefits, just as though you've been terminated for reason or whatever. You get all your benefits, but the difference is
Benefits like?
you get your vacation pay, you get your notice pay, which could be from a week up to 8 weeks notice pay. That's mean whatever you got paid for the week, you get 1 week notice for the time you're there, or up to 8 weeks notice, depending. If you're employed for 6 months, it's 1 week. 1 week. If you're employed for 5 years or more, it's 8 weeks. There's a scale in the legislation. It's also found that Section 45. Section 37, it says if you are terminated, these are the notices they have to give you.
Okay.
Notice means that you could work out the notice, or they just pay for the notice. Work out means, Marlene, you're terminated effective 2 weeks from now. So this is your notice now. You have 2 weeks notice. They can choose that you will work for those 2 weeks and pay, or they can say, we want you to leave now. So they give you
And
the
they
2
pay
weeks
for it.
pay. So you get notice pay. You get any vacation pay you have. So for the week under the labor law, apart from any personal contracts you can have, the labor law we're talking about, it would be at minimum 2 weeks vacation. So then that 2 weeks vacation, they pay you up front. If you have used 1 week already, they just pay you for 1 week.
Okay.
Then they have to pay you severance, and severance is a
If
whole
you meet
scale.
the requirement.
Right, if you 5 years, between 5 years and 10 years, it would be 1 week. After 10 years, it would be 2 weeks of your salary, but that 2 weeks only kicks in after 2011. After 2011 in the law change, then you could get 2 weeks for each year you've been employed. So you get your severance. One of the key things that we've always dealt with in labor issues is that the reason it's important for your employer to say it's redundancy is because under redundancy, you should not be taxed, because a redundancy package is to hold you to find another job. At termination, you are taxed, and that is very key. So your employer does you an injustice if they just terminate you at this time. You need to say, look, you've been made redundant. Your post has been made redundant. Now I get a lot of questions, people like, can they really just make me redundant? Who decides it's redundant? Because the place is still open and so, but if you go read Section 45, redundant doesn't mean that your post doesn't exist. There might be 5 of your posts when things were good, but now we only have 2. We may have had 5 cashiers, and now we only need 2 cashiers. So your post is redundant, not that there's no need for a cashier, it's that there's no need for 5 cashiers.
Yeah.
And one of the things in the redundancy section that it talks about is that you're downsizing. So a lot of people are downsizing right now. So that's if, so I'm talking about where you stay employed under Section 32, but you're not getting paid. Yeah. So you stayed employed for those 30 days, you're still accruing all your benefits, your employer should still put in your submission for your Social Security so that you don't lose your sickness benefit and any other benefit. Yeah. Or your employer says, I am not certain what will happen after this. Let me not hold on to people, because after 30 days they would expect me to hire them back. And let me just bite the bullet one time and terminate them or make them redundant one time, and you get all your benefits, but they shouldn't take out your taxes. That's the scenario, but there's a lot of in-between
There's
scenarios.
a lot of gray areas, yeah.
Which is why I was going to say, I'm glad that you drew that distinction because, or described it in those ways when you explained that redundant may mean that the post may still be necessary, but it's just that they may not need as many, because one of the reasons that an employer can actually dismiss an employee is because the contract has been frustrated, which means that it's it means it's impossible to perform. Meaning that if you've contracted with an employee to do something, and the easiest example is probably a tour guide, an employee in the tourism sector, I should say. Because in several cases, it's impossible for them to perform their jobs now.
Right, because the cruise ships stop coming.
Yeah, exactly. And therefore, the post can actually not be filled by anybody because there's nothing to do. And that would be a reason, could possibly be, once the requirements are met.
And I'm glad you brought that up, because remember I said, to me, my interpretation is that when the state of emergency comes in effect, clearly the whole pandemic thing comes into effect as an act of God. But one of the reasons indeed under Section 2 is that the contract has been frustrated, so you remain employment. And that's a good thing you bring that up, because a lot of people in the tourism sector are saying, they sent me home without pay. Well, because the contract has been frustrated, and it has been frustrated since then. It would be that, I think it's already over a month for those in the tourism sector, or maybe some more, those in the hotels. It's frustrated, but the employers have to be clear as to what section they're using. They can't just tell people you're going home. I don't know what will happen. They have to tell you, look, under the section of this labor law, I'm allowed to do this. You're still technically employed, but I cannot pay you because the contract has been frustrated. And however, I wish to still keep you on our records as an employee, but these are the provisions I'm making for.
How important is it to get clarification in writing? Because we tend to be a very informal system at times, and so maybe it's a small company and the employer says, well, I can't do, because you're not being terminated or made redundant. I'm just saying, listen, it's really tough. Can you just go home? We're going to close up shop, and when I need you again, I'll bring you back, but I can't pay you in the meantime.
Yeah.
Should you get something in
yes,
writing?
Yes, you should get something in writing for two reasons. Not only does it protect the employee and they know where they stand, but it protects the employer too. And I think one of the problems we're having is that a lot of employers, they just don't know the labor law. They hire people and they don't know what they can or can't do. And with all good intentions, sometimes they violate the rights of the employees. And if they would know the law, then they would protect themselves. For example, if employers knew that under a state of emergency / act of God, the pandemic as we call it, that they can still keep you employed but don't have to pay your salary, a lot of problems would have been avoided, but some of them didn't know. And some of them, it didn't matter. So I must say, I got communication with quite a few employers who knew that, during this time I don't have to pay you, but who then opted to still pay. I know I need to clear that up now, because it's very important for the employer to say, I know I don't need to pay you, but I'm going to pay you, and why? One, if they said during these 30 days, I'll still give you your salary, it has to be that they're saying, I opt to pay you no matter what. It's a salary, even though I know I don't have to. Fine.
Because in a state of emergency, your employer, if your business is closed, your employer does not have to pay you.
And you will rely on act of God or frustration, as Gavin says, right? If you pay your employee right now, do not later, if you're not clear, if you don't tell them clearly what monies you're giving them and why, do not expect later to come and say, oh, remember those 30 days when I didn't have to pay and I paid you? You had to be clear why you're paying them. There are some employers who are paying their employees during this time. I am paying my employees. I know I don't have to, but
and some are giving minimal allowances.
And not
to,
only
I don't know
that,
what you call it.
I put them. I said the way we'll do it, we'll put you on standby. So it's true you can't come, but there's an emergency here or there at court, then I could call them. I'm hoping to be able to do that for 30 days. So I can't. And
you put that in writing?
It has to be. We don't have hours in writing, because to me they're still employed.
Okay.
If that changes, then I would put something in writing. If I think the 30 days come and I really can't make it, then I have to put something in writing. My understanding with them is we're still employed. You're still on call. So then I can't have you on call and not say I'll pay you, right? But my place is small, and we know that attorneys, although they didn't put us as essential services, the court system can't work without us. Like yesterday, I was at court virtually. The judge and I were on a video call, a video conferencing, dealing with an emergency matter. So I know I still have to work. If my secretary needs to come in and get documents to file for me, she's on call. She doesn't have to always be there, because we know that the court can never fully close down. It has to deal with emergency. So that's my situation. But other employers, what they've told me is that, look, I want to help my employees. I think it's unconscionable to send them home 30 days without any money. What can I do? Well, there were several suggestions I put out. That's after speaking to one of the labor officers to hear them out how they see it. The employer could say, look, I can't really take a loss, but what I can do is if you have any vacations owing, I will pay your vacation. I know their employees are upset. Why they force me to take vacation? Come on, work with your employer. It's best you take your vacation money now than have no money. It's best you do that, because then you think we want everybody to survive.
So that's one option people have taken, to ask people to take their vacation and you pay them.
Right.
And that would be 2 weeks.
I mean, I had an employer who says, all my staff said, no, they won't take their vacation, that they want their money. And she says, do I have to pay them? I said, you need to inform them that you don't have to pay them. So work with your employer. The other thing you can do, you can give a salary advancement. But under the Labor Act, the only amount, only up to 1/3 of the value of your salary. So let's say you get $900 a week. It's only $300 a week I can advance to you. So they will only be able to advance you 1/3. Some people will agree to that. Other people, what they have done is say, I'm going to give you a loan. I mean, for those 30 days, and then when we come back and things are normal, I will take out the money I gave you from the loan over a period of 6 months, 12 months, 24 months. But that was to help you over, because you know that I don't have to pay you.
And again, you should do that in writing.
Please do that in writing. Another option that people have had is that I'm going to give you a gratuity. It's not a lot, but I'm going to give you a gratuity. Like I know one employer said, you know, I just went and I gave all my employees across the board $300 and say, you know, that's just a gift from the company. Go buy your groceries or whatever to get ready. So, I mean, they're different things. But I think what's important is to be clear what is it you're doing. So for employees, at this time, you can remain employed, but you do not get a salary.
All right,
for employers, the same thing. You need to know that you don't have to pay their salary, but be clear what you're doing.
So we have a question about construction workers. What should you do with them? Now that you are no longer, yesterday the Prime Minister said that construction work is no longer an approved business to conduct in the state of emergency.
Yes.
So I'd imagine anybody who was working up to yesterday can no longer work today.
Right.
What do you do with them?
So no, construction workers are usually paid by day. For anything from $35 a day to $100 a day, depending on their skills. The danger with that is that it's not like you have a full-time employment, like, you know, like someone that is hired here as a cameraman. There's like a full-time employment. You're paid day by day. Now, that will vary according to what were the terms you were with your employer. You know that it's just a project you're there for. You know that if the project is on, you get work. If your project is not on, you don't get work. So the same Section 32 applies. It means that if there's no construction site, there's no work for you to get.
And does this happen even with oral contracts? Because sometimes these people are employed without any kind of written agreement.
Many times it's just an oral contract, yes, but employers need to be fair and employees need to be able to understand, and this is where we've failed over the years to teach basic things that affect your everyday life. We're all employed at some point. We all enter contracts every day at some point, and we're failing to explain that to people. So back to construction workers, what can you do? You know the project will continue, so you have to tell the person when the project continues, I'll pay you whatever. All the suggestions I made of giving them advance and stuff like that, you can do that. Now, when we construction workers are like casual workers, it depends on what the terms are. If it's for a period of a project, you're in a better position because you will be able to, your employer should be paying your social security and all those other benefits just as though you're full-time employed. I'm sure you're working more than 8 hours a day, so you have all the benefits as though you're full-time employed. All the burdens also go with your contract burdens, meaning the fact that they don't have to pay once you're not working and they can continue. It's an oral contract. But I think they're more at a disadvantage. I've always said to me, casual workers like that are more of a disadvantage, because if you look strictly at the meaning of the contract of employment, it will not be a contract of service, but more for service. They're giving a service for a period of time. It's like little mini contracts, individual contracts, as opposed to some engineers that may be working with some big companies. So like M&M Engineers is a well-known company. They're into construction. They might have employees that they have full-time. That's different than the guy that walks off the street and they give a job from day to day,
who's paying a daily rate. Yeah.
So the truth is, I've always said, our labor laws do not really favor employees. You're at a very disadvantage. The mere fact that they can just terminate you with no reason now since 2011, it does not favor employees. And the truth is, our labor department is not properly staffed to handle the load that's coming right now. And even when we do not have the load, I mean, some of them will be upset, but the reality is that they've never constituted the labor tribunal. This is when you need the labor tribunal, so that a lot of people won't be able to go to pay an attorney to go to court, because what they will pay and what they will get, it cancels off. It doesn't make sense. I know that I was given several numbers to call because labor officers are working from home. And I'll tell you my experience, not one of those numbers I called, anybody answered. The one person who answered told me that he's now retired, but I'm glad he did answer and gave me some answers, you know. So that it's a really bad time for workers. It's really a bad time, and that's the truth.
And I want to come back to that. What we'll do actually is take a very quick break, and when we come back, we do have some questions coming in online. We'll get those so that we can put them forward to you, and continue the conversation about what employees need to know during this time. So we'll take a break, and we'll be back in a few.
When someone you love becomes a memory, the memory becomes a treasure. Channel 5 introduces the Daily Obituaries. The Daily Obituaries will broadcast all death and funeral announcements and memorials to honor your loved one's life and memories. The Daily Obituaries airs on Channel 5 prior to the evening newscast, with subsequent repeats at 10 p.m. and 12 noon the following day. It will also be placed online on our social media platforms, all for a standard package fee. Celebrate their lives and memories with Channel 5's Daily Obituaries. Honor in life and reverence in death.
By Full Text Systems. You'll come for the price, but stay for the service.
And we are back with our COVID-19 update, and of course we have Attorney at Law Audrey Matura here to discuss the multiple employment issues that have arisen because of the state of emergency that has been declared in the wake of the COVID-19 pandemic. Now, during the break, we were actually having a bit of a discussion, and one of the topics that we had touched on was, what are the options that are available to an employee in the case, or even an employer in the case where there are certain businesses which were actually forced to close down by the government under the declaration. Those things are like salons, barber shops, casinos, bars, and we also know that certain, even where businesses were allowed to continue, they had to continue operating a different way. Easy example is restaurants, where they're only now open for takeout, so they have no need for waiters and waitresses. So if your business, if your business was forced to close, or you know your employment was basically put to a halt or an end because of what happened, what are the options that are available to the employee or the employer?
Okay, so under the present labor law, if your business was just to close down, like the casinos, let's say, it's closed down, and so your employer doesn't have to pay you. They really don't have to.
Does that take effect from the quarantine order? Because there was the quarantine order before that closed bars, casinos, and I think restaurants, dine-in for restaurants.
It takes effect since then.
Okay.
Let me tell you, let me finish with that though. So if that's just closed down, Section 32 applies. The employer has to decide, will it be redundancy, or when the time is up, come back. You still have a job, I just can't pay you right now. But the same example you gave me, like the restaurants that are doing takeout, no, it means that some staff will be sent home. So Section 32 applies to them, but some staff will stay. With those who stay, if they're hourly rates, well, you have to pay them by the hour. But if it's daily rates, it doesn't matter how much hours for the day they work below the 8 hours, because you have them on a weekly salary. You have to pay them their full salary. The fact that you're only, like right now, the government is saying some of these establishments will only be open to 4 o'clock. So I think they open between 9 and 4. It's still not the full 8 hours, but because you have the person on a weekly salary, you still have to pay them their full salary because you have them employed. Even those people who are on call.
So if you were paid per day, you still should collect your full salary.
Your full salary.
But if you were paid per hour and your hours are reduced, your salary can be reduced.
Yes, just to the hours you work.
Okay.
And people,
because some employers have opted to reduce hours as a way of reducing salary because they can't meet the
but
wage bill.
that only works if you're an hourly worker.
Yeah.
But I always say, during this time of crisis, you and your employer can renegotiate. So there might be places that says, look, it's 50 of you I have employed. Our business will stay open because of the nature of the business. However, I cannot afford, this business is not as good. I cannot afford to pay all of you 50. Can we reach an agreement during this time? Can we all agree that we either all take a pay cut so that everybody stays employed, or we lay off some people and pay the others full? You know, these are discussions you have to have. It's gonna. A friend asked me what was my biggest fear about COVID, and I said, apart from people just falling and dying, is the economic collapse we'll have. And I wanted that addressed immediately. For example, I really expected that under the state of emergency, the government would have looked at regulations specifically addressing employment in different categories and not leave it to the labor law. That's very lacking. But clearly, they are not calling in all the expertise to say, you know,
That's an interesting perspective.
Let's make
what do you
certain
think
provisions.
should have been included in the state of emergency regulations to
for
make this an easier topic to discuss?
Well, for one, as the labor law stands, they say only 1/3 advance you can give us on salary.
Okay.
But they could have amended it to say at this time it could be half of the salary because you don't want the employer to be violating.
Okay.
For two, it could be that they could have made some kind of provisions, I believe, that if those businesses that were approved or stayed open and had to have limited hours, remember some of them are hourly workers, so they could have said, yes, you will pay them hourly, but because of the risk they're taking, you're going to pay them a hazard allowance or some kind of allowance, because these people are really becoming kind of frontliners.
Yeah.
In terms of the essential services that must exist, I think the labor law as it stands doesn't fully protect them, because yes, they will be getting their usual salary and everything.
Okay.
However, usually you have to find your way to work when under normal circumstances. Right now it's not normal circumstances. You might be taking taxi every day, so there had to be some kind of allowance to help you get back and forth from work. And also, I think that some of the things that they should have also done is during this time, because we know, especially frontline workers, both in private and public sector, they should have made provisions not only for the extra money that they said they would give them, but also make regulations as to a limit of hours that they can work, because you cannot have them overwork. Put something in place that they are priority to be tested. Like I would say, our frontline workers, maybe you test them every month, every week. I don't know. But I just think that there would have been regulations, because this is new. Don't worry about where labor law says and all the other laws. This is new, so you have to be innovative and think, what are other things I need to address? Because the most important capital we have is the human capital.
Absolutely.
And we cannot expect those people, those human capital, to work under these stressful and constraining times and not think about the labor law is not addressing some things to them. This is where you, as the leadership of your country, step forward and look at the different scenarios, because it gives you a sense of comfort. It makes you feel that I am valid, I'm important, and they care about me.
Yeah. And I also, I was just about to say, just to add slightly to that, and it also occurs to me that the labor law itself, even though we're talking about that 2011 revised edition, the majority of the act is based on a 1960 act, so a lot of the provisions are quite old. they don't necessarily apply to modern, and
to
especially
this,
for a
to this
state of emergency.
situation, to this situation. A state of emergency, which we had over 30-something years ago in 1981 when we had Heads of Agreement, has nothing, no appearance or similarity to this state of emergency.
Of course.
You know, that one could have been controlled and stopped at some point. This one is just beyond us, beyond our borders, beyond everything. And I think there could have been some basic regulations put in place.
And there's still time, because we don't even know if they may have to extend the state of emergency. So these are things that they can look into.
Let me tell you, like, one of the things that they had to put in place that I believe, right? A lot of us have insurance. And knowing some of these insurance companies, they will say, well, if you die from COVID or if it's COVID related, that's not covered. You can't even imagine. They need to make, you don't care where those companies come from, you need to make the enactment now to make it clear that they will not allow insurance companies or anyone to find a loophole to say that COVID is not covered, because nobody knew COVID would come. It's like some of these insurance companies say, look, plain HIV is not covered, you know, certain major illnesses. So I know it's a lot to think about, but the reason I always thought the leadership would get all your heads of department, not only CEOs, because CEOs are politically appointed, get your entrenched public officers who are in the system and get advice, because you have to look at everything that's happening. You have to look at education, you need to look at health, you need to look at employment.
Speaking of education, let me get to some of these questions here. So somebody's asking, what about teachers? For example, a teacher is newly hired starting April. He or she is not replacing a teacher on long leave or maternity leave. They're a full-time teacher. Should that person who's newly hired but because of COVID-19 can't report to school, should that person be paid in full?
Oh my God, that's an example of a contract being frustrated. That teacher would...
So they should have started this month, but there's no school.
So several answers to that. If it's a government entity and you already get hired as that, and you can't report to school per se, because these schools are doing online, then you can find where you could say, well, I can still report to school online to do my work. But if it's a situation where you can't do anything, you can't report anything,
you didn't get the chance to start.
That contract can be deemed frustrated, and the employer does not have to deal with you, especially if it's in the private sector. It's the reality. It would have been different if you were already employed, you were some days at work, and then this happened, and they said, well, we all go home and we are doing the distance learning. So, I wanted people to know too, a lot of people are working from home and doing working from home, as we call it. Once you're working from home as though you're fully in the job, you have to be paid fully.
Yes.
So if you work at a bank and you're running your same schedule and everything, you're still employed, and you've always been paid weekly, you have to be paid fully, even if your boss says, well, you know, you only need to work 5 hours instead of 8 hours. So that teacher is in a predicament. Their employer could say the contract has been frustrated, which it has, because it cannot be performed.
So let me go to another one. So you spoke of employers offering vacation pay, like asking people to take their vacation and paying them during the state of emergency. This person is saying, what if an employee was supposed to go on their first holiday after a year working, but it was interrupted due to the virus? Will it still count?
Okay, so I don't understand if interrupted meaning they were called back to work. If you were called back to work, well, then clearly you still owe your vacation. Go back to work and get paid as normal and reschedule your vacation. If it was interrupted meaning that, well, it's not fair, I'm on vacation now, but I can't go anywhere because I am quarantined or shut down because of COVID, you should say thank God, because it means that you're on vacation, so you have to get your vacation pay. Otherwise, you would have fallen in the category of people that are home right now and don't have to be paid, because that's what the labor law says. That's why I am saying to employees,
this is where
take your vacation pay.
This is why the legal profession is interesting, because my interpretation was different. I thought that she meant she was going to complete a year, because usually you're not eligible for your vacation until after a certain time. So what if I haven't completed that full year yet, but they want, so my full year is interrupted. And I have to, it's state of emergency time.
So remember I said, during this 30 days, so let's say she already made 11 months and these 30 days makes 12 months. During these 12 months, you're still accruing your benefits. So you remember, you're still employed, you're just not getting a salary. Remember, your employer should still be paying your social security, you're still employed. So this 1 month will complete your 12 months. So after this 12 months, then your vacation becomes due.
Yeah.
So remember the
But if I
section
want to
32.
give you vacation, if I want you to take vacation with pay, can I do it for less than the 10 days? Because isn't the benefit based on...
Well, if in your employment contract, some people have 3 weeks, 4 weeks, but under the labor law, where you don't have that employment contract with those details, it's
Yeah.
only 2 weeks. So if it would be 14 days, and it would be prorated if you want to take your vacation. So if you were short by 1 month to reach that 14-day mark or that 2 weeks mark, it just means that the employer will take out the 1 month, they will prorate it,
Okay.
and you won't be paid that month, but you're due. So people tend to feel that I have to complete the whole year to get my vacation from the whole year. No, if you only work 6 months out of the whole year, you get half of the vacation. If you work 1/3,
It's just that you
3/4.
can't get it
Right.
until after, well,
Right.
you in normal circumstances.
Yeah, I mean, if they fire you before the year is up by 1 month short of the year, you're still entitled to your vacation pay if you didn't take any vacation.
So there's an added layer here, and I started the show saying that I pass Social Security every day, over the past few days, I should say, and seeing the people out there, it's so disheartening to imagine people facing this without having employment. But there's a gray area that's been established. The unemployment benefits of people who've lost their jobs. Originally, they said tourism. They seem to have thought about extending it a bit. But people who've lost their jobs due to COVID-19 or due to the pandemic. But what about these people, especially in the tourism industry, who've been sent home maybe from a month ago without a salary and been told, you know, well, when business picks up, we'll get you back, but we can't pay you in the meantime.
Yeah.
They're technically not eligible because they're not
Yes.
unemployed. And, you know, I know people think that
Yes.
employers are heartless, but I have people calling me and saying, should I just fire my employee and then that way they can at least get some money from the
redundancy
government?
benefit.
But then they lose years of service, they lose other benefits in that meantime. So what do you encourage an employer
I'm glad
to
you
do?
bring that up because it is a gray area. I did get a call where the person says, look, I can't pay my employee right now, but I don't want to fire her. And she's trying to fill out this form, and it says that you're unemployed. And we're viewing unemployed in the strict sense that you don't have a job. But she has a job because she can always come back to me. What do? I said to the person, let me tell you, let her still apply, because for now she doesn't have a paid employment. She has a placeholder that says you can always come back and I will continue your years of service. But are you without employment salary? Yes. I really believe that that needs to be amended, because all those people in the tourism sector were not people that were self-employed. Some of them were working with someone, and they can always go back. They're just not getting a salary. And I think that gray area needs to be addressed promptly by the government. But in fairness, the suggestion I would make is that the benefit is not so much unemployment that you have to prove that you're not employed, because you still have employment, you're not being paid. It should be something that you categorize as though you're not getting employment salary.
Yeah.
So
like
that-
some kind of temporary relief system.
Yeah. For some it will be, absolutely they lost their job. For some it would be, I still have a job, they just can't pay me because Section 32 of the Act, which you, the government, did not amend and did not make any special regulation, boxes me in a gray area. And the intent cannot be that people will use loopholes to box you in a gray area. It should be that you genuinely want to give relief.
Because it's a hard situation. If I've closed for a month or two and I don't have bookings till maybe May, June, if it's a small place, and my employees with me for 8 years, and I let them go, they're 2 years away from collecting severance, it's a tough call. I might tell you no money for 3 months, but don't worry, when you retire or leave the job, you have your severance. It's so hard.
But you
for
see
people
why
to
I had
decide.
said that I would think that under the circumstances, because there's a state of emergency, a very unusual one, that one of the areas that the government would have been reviewing is exactly the employment area. So that and they can do it, because remember, under a state of emergency, you can put in place all kind of regulations, policies, and so you can amend legislation that you want. There are things you can do to create relief. And the truth is, like you said, that's a massive gray area. So should you apply, I still say to people, apply. Apply and show that although you have a job, you're not getting paid. And the idea of the relief was to make sure you get money while you're not working. You're not working because it's frustrated, but can you go back and work? Yes. And so I don't think people should be discouraged from
Just
applying.
apply. Maybe they should
Another
do
one-
the paper one and they can write the notes in, because I don't know if the online one allows for it. Has anybody tried it?
I haven't even tried it.
looked at
Okay.
I
Yeah.
just looked at it. But listen, another thing that people asked me was, can a small business apply for the relief? And my answer is yes. The reason my answer is yes is because you have a small business, be it a sole trader or whatever, you don't necessarily have to go apply under the business, apply as the business owner. And I think that's another gray area, because that relief, when you look at the categories of people who can benefit, they never said and a small business, you know, a small companies, but many people are operating only under a business name.
Yeah.
So you, as the person operating under the business name, go and apply for the relief, because your work too has been frustrated. Some people think that, oh, because I am the employer and I'm equally impacted as my, so imagine a tour operator, he's the employer. Can he, the boss tour operator, can he go apply? Man says yes, because you are unemployed too. Yes, you own the little business, but you're not getting a salary either.
So let me go back to some of the questions here. There's another one for teachers. If I was scheduled to take long leave effective April 1st, but schools are shut, will it be given at another period?
Nope, take it one time, because your long leave right now means you get your full pay.
Okay.
You can't have it all.
Yeah.
You take your long leave right now. Don't
Okay.
put it off another time.
This
Try as much as possible, see that everything stays in place, except this part here.
So this other one is saying, will a letter of leave without pay assist me to apply for the $75 assistance?
Yes.
I will not appear as unemployed with SSB.
No, you have to do it. The SSB, in reviewing their decision whether you get money or not, has got to be practical. They failed to make clear the rules. Remember, when we do interpretation of law, what was the intent? What was the mischief they were trying to cure? They were trying to cure a situation where people, although technically were employed, were not getting a salary.
Okay.
They did not have employment at the time that was paid for. They have a security of a job that they can go back to, but they're not getting a salary. So yes, you have not been fired. Yes, you have a job to go back to. But during this time, are you making any money? No. Go and apply. Let them be the one to tell you no. It would be foolish of them to tell you no, because they're the ones who created the gray area. And you have to look, what was the intent? When I heard what the Prime Minister said, I think his intent was to give relief to all those people who are not getting money during this time, because they are not doing employment, they're not on the job. It doesn't mean that they don't have a job they can go back to. It means that they, under the law that we have, the labor law, says that your employer does not have to pay you right now. So I would not discourage anyone to assume that you don't qualify. Go, and in the meantime, we will lobby and we will make it known that some of what is the way the strict interpretation does not make sense.
Yeah. So before we wrap up, any other questions that you've been getting quite a lot about employment issues that maybe we can bring to light here?
Well, I think one of the areas that needs a little bit of addressing would be where we have people on the front line that I do not believe are being treated properly. And one of the questions people ask me that are frontliners, can I refuse to do certain things? And I think that's critical to address. My answer is yes, because your employer has a duty to create a workable, healthy working environment. So if, for example, there are people texting me and telling me and showing me what they're being asked to wear, and those PPEs, those personal protective equipment, some of them are very lacking. And so if you have a choice between life and death, if you know that this is not good enough for you to do the job, under the labor law, your employer needs to give you good equipment as well. So that qualifies of equipment. So you can't refuse. What I will do then, if you're in such a situation, put it in writing, take a picture, record it so that it be known. It's not that I don't want to do my job. It's just that you did not give me the proper tools for me to do my job in a safe environment. Remember this OSH bill that the unions were pushing? This is a perfect time for OSH, because yes, you are a caretaker at the morgue, and you are going to be taking out the bodies of people who died from COVID. You still need a protective gear.
Yeah.
Because that body is now infested with that
Yeah.
virus.
Well,
so
they
they
won't be
can't tell
allowed to
you,
go to the morgue.
they can't tell you, go move that body and not give you the equipment. You can refuse then. So that is one of the question I'm getting from a lot of the frontliners. Can I refuse? The other reason you can refuse to, if you know you have a pre-existing condition, please go and get your documents. I'm being told that some doctors don't want to give people their documents to show that they have a pre-existing condition. Please find someone.
For work?
Yeah, for work.
Okay.
Right, but it's important. If you're pregnant, please bring your pregnancy paper. They cannot expect that you're pregnant and you're going to go do hazardous
So
things.
you can go if you have, okay, so let's say I'm diabetic, right?
Yes.
I'm not. And if I was, I probably wouldn't be in this space
Yeah.
because I would be high risk.
Yes.
But if I was diabetic or I'm on
Asthma.
cancer treatment or
Yes.
something else along those
A
lines.
cancer survivor.
I could take that, get a letter from my doctor and say, I am a high-risk patient in this pandemic,
Yeah.
and present it to my employer
Yes.
to do less risky
Yes.
part of a less risky part of the job.
Yes.
Okay.
Yes. And remember, you can ask for sick leave in that sense.
Okay,
And that's
I didn't know that.
that's a gray area for some people, but we
It is.
tend to think about sick leave as just you're sick and so they want to put you out. But this is, you're sick with a condition that if you put yourself at risk, you're gonna die. I mean, your chances are like 99%. No, but
Yeah.
it's true.
No,
and,
I'm just
and so frontliners, you do have the right to say
Yeah.
no. Just record it properly, because if you go and then you get injured or whatever and you get sick and maybe possibly die, your family then has the right to go sue your employer because there was negligence. But you don't want to reach that. You don't want
Yeah.
your estate to be suing you because you're dead.
Yeah.
Because the amount of cases we'll get like that.
And I do want to say, because while I know people hear the conversation and I think that all employers are just being heartless, there are some places
No.
that have sent home high-risk people from day one.
Immediately.
There are some
Yeah.
that have pushed for them to work at home. There's
Yeah.
some that are finding money to pay their
Yes,
employees.
that's true. That's
so
true.
it's not across the board that people are just being completely heartless
No,
in this situation.
it's not,
But
it's
for
not.
those who are in a situation where they feel that they're being treated unfairly, we hope that we've answered some of your burning questions. Audrey, we appreciate it. This was a necessary conversation to
Yes,
have.
well, thank you for having me. Remember, we're not shaking. It's namaste now. It's
All
namaste.
right. We're going to go
Namaste.
ahead and take a break. And when we come back, speaking of high-risk patients, we're going to be joined by a journalist and also a renal patient, Glenn Tillett, talking about, being a high-risk person in a time of COVID. That's coming up after the break.
COVID-19 update was brought to you by Full Tech Systems. You'll come for the price, but stay for the service.